5 seconds to go. Start. Reliance on the above provision is misconceived as both the clauses must be interpreted to deter usage of the applicant's proposals, representations, and allied information before courts tribunals in the event the settlement fails. It does not deal with the disclosure obligations cast on SEBI. In any case, the purpose of settlement is to ensure that parties come to an understanding having assessed their relative merits. It is expected that parties in such proceedings are transparent, more so for regulators like SEBI, who are expected to share all the documents which are necessary for understanding the issue. It is a matter of record that subsequently the settlement proceedings were terminated by SEBI, and thereafter SEBI has decided to initiate a criminal complaint against the appellant herein. In this context, the objection of SEBI that the issue of disclosure of documents is res judicata, as the same was disallowed by the High Court in the earlier round of litigation, cannot be sustained in the eyes of law. This brings us to the right of the accused appellant to seek document disclosure in the present case. In this case, the appellant has been pursuing SEBI for these documents as they believe that an attempt is being made by SEBI to suppress the opinions and reports as they are adverse to the cause of SEBI. A cursory glance at the background of the matter would reveal that initially a complaint was submitted to SEBI on 21st January 2002, wherein the appellant and its directors were purportedly involved in irregularities in allotment of non-convertible debentures in the year 1994. Accordingly, an investigation report was submitted by the investigating authority on 4th February 2005. SEBI, in its counter affidavit, has admitted that the aforesaid report was inconclusive and recommended further inquiry in this regard. In pursuance thereof, SEBI approached Justice Retired B.N. Shri Krishna in the year 2009. He is supposed to have given his first opinion, which formed the basis of initiating action against the appellant herein. It is SEBI's case that during the settlement proceedings, the appellant had disclosed numerous documents which mandated SEBI to re-examine its stand. Accordingly, the matter was referred to Justice Retired B.N. Shri Krishna for a second time. Thereafter, Justice Retired B.N. Shri Krishna wrote back to SEBI asking them to consult Shri Y.H. Malegam, a renowned chartered accountant, to determine the culpability of the appellant and various directors. It is reported that this exercise had culminated in the second opinion of Justice Retired B.N. Shri Krishna. SEBI is a regulator and has a duty to act fairly while conducting proceedings or initiating any action against the parties. Being a quasi-judicial body, the constitutional mandate of SEBI is to act fairly in accordance with the rules prescribed by law. The role of a regulator is to deal with complaints and parties in a fair manner and not to circumvent the rule of law for getting successful convictions. There is a substantive duty on the regulators to show fairness in the form of public cooperation and deference. Stop.